Oh, yes, that's right. Lordship, I'm seeking a short pass over. Meet after the next matter, Lordship. All of a sudden.
Go next. Yes, Shankar Narayan is next.
I'm sorry.
Huh? Say,
Yes.
Lord Shiva is available everywhere. Huh?
Not only Lord Shiva, Narayana also.
Well, both.
Both are there.
Shiva, Narayana, both. Huh?
In fact, Shankar Narayana, my lords, there is a temple, very famous ancient temple in Tamil Nadu for Shankar Narayana, where Shiva and Vishnu are together.
And
Yeah,
not
that
one
that
side.
that
We have-
deity is called Shankar Narayana.
We have to see other side also.
That side also.
Murti.
So why fight? Settle it.
Because I have a short note which I'll just hand up to you in a minute. Your Lordship mentioned earlier that you've gone through
Short note.
the issue. Broadly state what.
Short note. Nice short note.
No, I will hand it up. I'm
Oh.
just getting copies.
But here.
I will hand it up. This petition is on behalf of 1,301 individuals. These are individuals in the state of Jharkhand who are all Jharkhand TET qualified candidates. Now, this question which is at the heart of this case is simply this. Is it enough for candidates who are available and who are properly eligible and qualified with the Jharkhand TET qualification, who are sufficient in number to fill up the posts, to actually be available and to be considered for filling up the posts? Or is there a necessity for the government to go further afield and get those who are not Jharkhand TET qualified, but who are qualified in TETs which are conducted either by other states or by the central ctet as it's called? The background of this case effectively is that some individuals who are not Jharkhand TET qualified individuals moved the High Court in a writ petition. And they said Jharkhand has not conducted the TET for the last 3 years or so. So our opportunity to become eligible has been deprived to us. A concession is made by the government. We are not parties there. Concession is made by the government.
You were not there before the High Court.
No, we were not.
Who are you?
We were all eligible and qualified and sitting at home. So we were not invited, we were not parties. The people who moved the High Court were those who did not have the Jharkhand TET qualification. They said, please conduct the exam. So
It means you were applicant somewhere or something.
we filed a challenge thereafter.
You, Mr. Shankar,
Yes. Yes.
Advertisement was issued.
Yes.
Advertisement prescribes some qualification.
Yes.
That qualification indicate this.
Yes.
As per that qualification,
Yes.
we have to purchase this qualification.
That's correct.
We are the person who purchasing, participated in the process of selection. We are not. Online
Correct.
process of selection.
Yes.
In the meantime,
Yes.
these are the persons who were from Jharkhand who has not conducted TET.
Correct.
So they went to the High Court.
Yes.
Then while they went to High Court, they asked that because of the state has not conducted this examination, those will be permitted.
Yes.
Concession was given by the government. On the
Yes.
basis of the same, they were permitted to participate and court passed an order.
Correct.
Now being agreed, because you are going to be affected by the same, you came before this court.
We have filed this.
You say like this.
That's I'm sorry.
So please give that
Every day is a learning experience, Manoj. I'll improve myself.
learning experience.
For me.
In the Bihar case, we will replace it. In the Bihar case, the state
Like one case may close. We are seeing every day this bunch is being attached. Then we find something is different. Let us come somewhere.
So, if your lordships can just take up that first paper book, Manoj, in Parimal Kumar. Yes, Manoj, for the exams? For the exams, yes. If your lordships are asking me about court, no. I come up.
You were not there, that is mentioned in the
Yes.
right?
Huh.
But in the selection process means against the advertisement you had applied.
Yes, of course. Of course.
Come to the advertisement.
Yes, ma'am.
Come directly to the advertisement.
Yeah.
Yes. So,
Okay.
it's
You are
in the
first
IA
case
for
now?
addition.
We are on the first case coming.
First case.
419.
So it's in the IA for additional documents.
Copy.
Page 35.
Application permission to place the additional document.
Yes, ma'am. In that page 35, if your lordships will take. This is in 2023. When is the rate price? 4467. ma'am.
Yes, please.
Yes. Your lordship sees this is the advertisement.
Yes. What is the requirement?
Qualification report. 142 of yours.
This is Jharkhand Teachers Training Competitive Examination.
It's page 142, my lord.
Page 35, not 35.
It starts at 35, I'm sorry. 35 at 142. It's very long.
142.
Yeah.
My paper book.
Page 149. no?
What you
Yeah.
have is the same.
Same. Page 142. It's this minimum educational qualification starts at 1. At 1. If your lordships wishes, I can show from 138. 35.
Right.
Yes, 35. The scale of pay and minimum educational qualifications for the posts mentioned in clause 3 are as follows.
So the post is intermediate trained assistant teacher.
Yes, intermediate trained assistant teacher, classes 1 to 5. And the minimum educational qualification is the last column, my lords.
Yes.
If you just come to 142,
Yes.
at the end, and so it's a conjunctive, and pass the teacher eligibility test. That's Jharkhand, JETT, conducted for classes 1 to 5 by the government of Jharkhand under the guidelines formulated by the NCTE.
Where is this?
Your lordship,
Which page?
page 142 bottom.
142.
And just this part, my lords.
Pass
And
the teacher eligibility
Pass the
test.
teacher eligibility test conducted for classes. It should be JTET, not JETT, for classes 1 to 5.
JET.
JTET, teachers eligibility. It's called the TET across the country. Each state's prefix will be there. Conducted for classes 1 to 5 by the government.
TET.
JTET,
JTET.
Jharkhand Teachers Eligibility Test.
JTET.
Yes.
Is it right?
Yes.
JTET. Class 1 to by government of Jharkhand under
Yes.
the guidelines formulated by the National Council for the teachers.
For teacher education.
So
Yes.
meaning thereby this JTET is under the guidelines formulated by National Council of Teachers.
By the NCT. That's right.
Yes.
Now, if I can pause here for a minute, I just want to take a minute to tell your lordships the statutory backdrop behind this. It starts with the RTE. Your lordships can just see the act for a minute, because it's a mainstay of
Where is that act?
the Right to Education Act. Right to Education.
Why go there? We have to see the rules and the qualification prospect.
I'll explain why. Because of, very well, I just want to show your lordship the entire backdrop of this. Starts with RT, goes to the NCT, which is nominated under the RT, the NCT's guidelines, and then these advertisements come. So I'm showing you the foundation behind the advertisement, and therefore the concession, this is the simple argument. The concession that they made before the High Court was legally impermissible. just by reading this. That's our argument. That's the beginning and end of it. That's all. So I can show you the rest of the documents, etc., but unnecessarily I'll take time because this is the heart of our case. Just give a copy. If you have a copy.
I can give. Yeah, same thing.
Same.
You have 2 cups.
Section,
Section 23, my lord.
another setting, other set.
I can
One of
You can take my footmaster.
All right.
अभी के लिए ये नहीं.
Yeah.
My lord.
Section 23.
Yes, 23(1). Now this is mandatory. It says qualification.
Yes. Wait.
So sorry.
Qualification for appointment.
Qualifications for appointment and terms and conditions of service of teachers. 1. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So, the minimum qualifications will be as laid down by an academic authority which will be designated by the central government, nobody else. No state government has any power. It's only the central government which can nominate what that authority is. Now, 2, for a minute. Where a state does not have adequate institutions offering courses or training in teacher education, so that requirement has to be fulfilled, or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers. These are the 2 triggers. In either of those situations, the central government may, not the state, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. So the scheme is very clear, my lords, from 23.
What is this proviso?
The proviso reads that a teacher who at the commencement of this act does not possess such qualification
May acquire within 5 years.
shall acquire it within 5 years.
Proviso?
Further proviso that every teacher appointed or in position on 31st March 15, this was inserted later in 17, my lords, shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the RTE Act. Now, the reason for the second proviso is that as for section 23(1), the first subsection, the authority had to be designated. That authority which was designated with a notification dated 31st March 2010. And you will find that at page 9 of the IA. Page 9. Actually, I'll just hand up this note so your lordships can. I have put it in my note as well. If your lordship just comes to page 2 of this note.
Let us see the notification.
Yes, I will. I'm just saying, I want to save your lordships the trouble of making notes because what I am submitting is in page 2 with the page numbers. So,
Notification is page number.
The only problem is
page 9 of the additional document.
Mr. Shankar, the only problem is if you want to add anything, there is no space.
On this.
We'll have to write out.
No, I agree. I'm just saying.
We should leave some space also for us to note down.
No, Milons, on page 2 there may be space. Just see page 2. Is there space? No.
Or like there,
Sorry.
we have to look at.
I'm sorry.
Come.
So we have to note down.
I'm sorry about
If the dates are there, that's all. Page number and date will get.
that same IA that your lordships took up just now to see the advertisement, page 9. Page 9 of that IA.
9 is in Hindi.
And the English bottom right
10.
side.
Bottom.
Page 9, bottom right side. Small para on the right side. Your lordship sees 31st March 2010 notification. In exercise of the powers conferred by subsection 1 of section 23 of the RTE, the central government hereby authorizes NCTE as the academic authority to lay down the minimum qualifications for a person to be eligible for appointment as teacher. Right, Manoj? If you're
So
not,
accordingly, this NCT has come into
NCTE is the singular authority and designated by the central government. keeping in terms of the Act. The Act, as your Lordship saw, in 23(2), provides that if either of those two triggers are satisfied, that you don't have enough institutions or not enough people, then the relaxation can be made for a state by the central government for a period of 5 years.
Interesting.
Yes. So one thing is clear, that the authority by central government will decide the qualification, and any relaxation for any state will be done by the central government.
Cite minimum qualification.
Minimum qualification. So the central government is the only authority that will decide that then. The state has no role to play. Now, just next page, page 10, my lords. Page 10 is dated 23rd August 2010.
Yes, please.
Yes. This provides for the minimum qualifications. It's by the NCTE. This is page 10 of the same IA. At page 11, if your lordships will see, after dealing with minimum qualifications, classes 1 to 5, classes 6 to 8, just above serial number 2 at the bottom of the page, your lordship sees pass in the teacher eligibility test. P. Lord Justice Bindal has it. Page 11, just above 2, in P, that second qualification, pass in the teacher eligibility test to be conducted by the appropriate government. Please mark appropriate government, because that is defined in the Act. In section 2 of the Act, appropriate government is defined, in accordance with the guidelines framed by NCTE for this purpose. Appropriate government, my lords, is in section 2A of the Act.
A.
2A of the Act.
Where is that?
Bare Act, my lords.
It's right to
Yes. Section 2, subsection A. Appropriate government means, 1, in relation to a school established, owned or controlled by the central government or the administrator of the union territory having no legislature, the central government.
Okay.
2 is what is relevant. In relation to a school other than the school referred to in clause 1, established within the territory of this capital A, a state, the state government. So the appropriate government, which will conduct this TET as required by the law, will be Jharkhand. So, reading this guideline at page 11, it's a mandatory requirement that they must pass the TET to be conducted by the state of Jharkhand, not any other TET. And this has to be in terms of the guidelines prescribed for that purpose. Oh, that's good. The guidelines your lordships may note is at page 222. In my note, it's the last line of page 2. Very last line of page 2. It's page 222 of the main SLP paper book notes. Page 222, it's dated 11th February 2011. If I can just read this, just Bindal has it, page 222. This is by NCT to all the secretaries, commissioners of education of the state governments and the UTs. Page 222, Maloj, Annexure P1. Guidelines for conducting TET. It's sent to all the state governments. Sir, madam, in accordance with 23(1), we did notification dated 23rd August. NCT has been laid down minimum qualifications, etc. it has been inter alia provided that one of the essential qualifications for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of section 2 is that she should pass the TET, which will be conducted by the appropriate government in accordance with the guidelines. In this regard, please find enclosed the guidelines. The eligibility requirement, my lords, is at page 223. Next page. Para 5. If I can just read in 5, small Roman 3. The following person shall be eligible for appearing in the TET. Small Roman 3. The eligibility condition for appearing in TET may be relaxed in respect of a state UT which has been granted relaxation under subsection 2 of 23 of the RTA.
This is not clause 3.
I'm sorry?
Clause 3.
5 small Roman 3.
Five.
Small Roman 3. I'm so sorry. Eligibility. Page 223. Last line of that page. That small Roman 3. So
For appearance in the TET test.
yes. So it says eligibility condition for appearing in TET may be relaxed in respect of a state or UT which has been granted relaxation under 23.2. So for 23.2, as I showed your lordships under the Act, that's the only place that the relaxation can be granted by the central government.
This is only for appearance in that test which makes you eligible for appointment.
That's correct.
So how this will relate here?
It won't. I am saying it won't. I am saying that if they were to try and argue that a relaxation is possible, the only relaxation, even as per the guidelines, is limited
This
to.
is not a relaxation for appointment as a teacher.
I'm grateful. That helps my case. Because as per the parliamentary law in section 23.2, the only relaxations that is possible to the NCTE's mandate is if the state government writes to the NCTE and says, look, I don't have enough institutions or I don't have enough qualified TET candidates in my state. Neither is the situation in Jharkhand. When they write like that, NCTE has to write back saying, very well, for your Jharkhand, we will relax it, and for 5 years, we will relax that condition. Nothing of this sort has ever taken place. If nothing of this sort has ever taken place, relaxation is not possible. That's our argument. So you can't stand up in an inter se writ among yourselves and tell the court, look, we will consider, we will concede, we will allow other people with TETs from outside to take part. That's our argument. I hope I'm making myself clear. The relaxation is mandatorily only by central government in these two triggers.
Come to then eligibility that
Yes.
on TET conducted for 1 to 5
Yes.
by the government of Jharkhand under the guidelines for the institutions. So, along with the qualification,
Yes.
passing of jtet is essential.
Mandate.
Is essential qualification.
Essential qualification.
Once it is an essential,
Yes.
so your saying is
Yes.
jtet which is required to be conducted for class 1 to 5 by the
Yes.
government of Jharkhand, National Council for. So jtet,
Yes.
if you passed out,
Yes.
that should be as per the procedure prescribed
Yes.
for appearing to that and
Yes.
passing it.
Correct.
And
How many of us?
that can only be as per the relaxation. And that relaxation is by the central government.
Yes. Now, in
jtet for TET.
so
You
no,
are referring of TET.
it's for each state.
They are asking in
Prefix
jtet.
maybe state
So the
prefix.
TET is the jtet. So for each state, Kerala is called ktet, Rajasthan is the rtet. So they put the state's prefix before each of these. So central is ctet. So I mean Karnataka, Kerala, there may be a difficulty, but this is how it is across the country. Now, once the jtet exam has been, you have enough candidates because more than 1 lakh of us have taken the jtet and we have qualified the jtet. So we are there. We're all available. This advertisement is for 26,000 posts, of which only 13,132 are available for us because of a reservation. Now the 13,132 is what we are eligible
This
for.
qualification is required by everyone. It's not that for reserved category this is not required.
No, it's for service.
Everybody will have conduct.
For it is required, this is the basic qualification required.
Para teachers are different.
Who are working as para teachers, so that's separate. That's what this for this 13,000 everybody requires. Everybody requires it. There's no relaxation.
Meaning of this 13,000.
That's the 50% of the posts advertised is 13,132. Of the remaining 50% is for para teachers. Who are already working in the state government. But for all them also, for
It
them
will
also,
be required
they
for
would-
that only.
they would require
Reservation of post for that
They
category.
would require that. But these people are already working as
That's
teachers. We are not. So for the remaining 13,000, we are candidates who are available and eligible. So there was no reason for those who are coming later, who have not sat for the exam when we sat for it, or who have not cleared it when we sat for it, saying that you have not,
In
sorry,
which year you had passed out?
2016.
16.
All of us 2016.
And this qualifying jtet
Yes, bro.
from the state of Jharkhand.
Yes.
This will be perfectly right for how many years?
It's supposed to be
Forever.
forever. Once you
Forever.
qualify it, you qualify. It's like getting a B.Ed or any other.
So you can
Yes.
that you can appear then thereafter.
Yes. You can appear there.
So now you come to the advertisement and when exam took place, then what facts of the case?
Can I just trouble you because I there are a couple of arguments against us which I must show your lordships also. So that guidelines I was showing you from the first paper book, page 226, my lords, I had read that. If your lordships can just see page 226.
226.
At page 223.
223. Now, if your lordships can come to page 226.
Applicability.
Yes. This is clause 10, applicability at the bottom of 226. A says TET conducted by central government shall apply to all schools referred to in 2A1.
This is Pan India, it is a
Pan India. That's a ctet. Therefore, the ctet can't apply to schools, conversely, which are not covered by 2A1. Second, B. TET conducted by state government UT with legislature shall apply to 1. A school of the state government or UT with legislature and local authority referred to and so on. So that's what we are relying on. That's what it will apply to. Now, just after that, a school at 1 and 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with a legislature. In case a state government UT with legislature decides not to conduct a TET, a school at 1 and 2 in that state or UT would consider the TET conducted by the central government. So this is in a scenario where the state itself is not going to conduct the exam and says so. That is not the state's position today. The state has conducted one exam which we have taken.
The clauses are
Yes,
TET conducted by a state UT with legislature
yes,
shall apply to
yes.
school of the state government UT with legislature and local authority. That means other states' qualification is valid if the legislature and all that is there.
Yes,
Valid.
it says a school at 1 and 2, a
So
school
that is sufficient.
yes,
Prior to that,
prior to that, a school of the state government.
legislature,
Yes,
state A legislature, state B legislature.
yes.
So qualification in state A is valid in state B.
No,
What is the meaning of this?
no, I'll. If
No,
your
want to
logic to look at 10B, 10B1,
B1.
10B1. I know, 10B1.
You
It
please
says,
kindly, Mr. Sankarnath.
yes,
TET conducted by the
by state government or by a UT with the legislature
Like Delhi is.
shall apply to a school of the state government or UT with legislature and local authority referred to in subclause 1 of clause N of section 2 of the
This
RTE.
will not be relevant here because this is only local authority defined.
Yes.
So that means any qualification from state with legislature or UT with legislature is applicable to all.
Within that state. For the government schools in that state.
The first one is central government. Second one is state government for the state government run schools. If you Lordship should see the definition of
So just a minute, let him complete, otherwise we'll not understand.
2N1, which defines a school.
2N1 is only for local authority.
No,
2N1 is something different.
2N1 is definition of school. So 2N1 says, if I can read that, school means any recognized school imparting elementary education and includes 1. A school established, owned or controlled by the appropriate government or a local authority. So all this assistant teacher recruitment that's happening, which is happening by the government, is for its own schools, which are covered by 2N1, which could be owned by the state or by a local authority, but 2N1 is what we are looking at, not private schools.
What is the meaning of this clause? If it is applicable in the same state, then there was no need for having this clause. Right?
No.
And if you read this with the first clause that the central government ctet is applicable pan-India,
Yes.
then the meaning of this we prima facie understand is that any test conducted by a state with legislature or a UT with legislature is applicable in the state with legislature and UT with legislature.
Correct.
It is equivalent.
So I'll just explain if I
This is what we understand.
Yes, I understand. So
Schools they have
break up.
Fine, no problem.
The way I understand this, Manoj, is this. 10 is in 3 parts. Now the first part,
Right,
which
first
is
part meaning we have
yes, no, but I'm saying
or different meaning.
the way I understand this is a division of applicability based on territory. That's the way I see it. 10A is dealing with 2A1, which is a central government institution.
How
so
can you
it-
say B is not talking about central government? It is state only. Central
Because-
is one. A.
2A1 and 2N1 are two completely different things. 2A1, if you just see 2A1,
Central government is 10A only.
yes.
10A. B is not talking about central government.
No, it's not. That's why.
So what is the import of 10B only? You just tell us that.
Just 10B. 10B is that if a state or a UT with the legislature, which is the appropriate government, makes here a TET exam is conducted by that state's TET would apply to all the government schools
This is-
or local authority schools of that state.
From where you are taking that state? That state for that no provision was required.
No, I'm taking this only because this
No
is,
provision was required for
I'm
that.
responding to your lordship's suggestion because these are guidelines.
Right. So for that no provision is required. That they had to issue guidelines for that purpose.
But very often in guidelines, they try to be as exhaustive as possible.
Not required at all.
So maybe it's superfluous, but
Yeah.
this is the only, let me just respond.
Flows any.
No, that is the reason. The only interpretation which I am giving is the one which is consistent with the act. If any other interpretation is taken, it renders section 23 nugatory. That it can't do. Lordship,
That
please
is a
section 20.
separate argument altogether.
No, I'm
Suppose we take
that is why the interpretation has to be. Yes.
Taken a different.
Yes.
If we apply 10A,
Yes.
10A is applicable to subclause 1 and clause A of subsection 2.
Correct.
We have no concern.
Yes.
10A goes out.
Correct.
Come to 10B.
Yes.
Suppose we go to 10B.
Yes.
Then it says conducted by a state government, public duty,
Yes.
with legislature shall apply.
Yes.
All right. So now what we have to look into, TET conducted by the state government
Yes.
or by the UT
Yes.
with legislature,
Yes.
it will apply to whom? Now come. A school of the state government or
Of the. I'm sorry, but I'm saying the.
government.
If you just compare this with the above sentence, which says a state government, TET conducted by a state government shall apply to a school of the state government. So whichever state government conducts that, it is to them that it will apply. Otherwise, they don't have to do A and the separately. They would say A or any state government. They haven't used A. They haven't used any.
All right, fine.
Yes.
So, but it is also using the word the local authority referred to in subclause 1,
Yes.
clause n or so and so. 2
Yes.
and n, we see that
Yes.
2 and
1. Yes. A school.
2 and 1 is
A school established.
owned and controlled by the appropriate government or a local authority.
Yes.
Alright.
Yes.
Appropriate government or local authority.
Yes.
So here the state government means it indicates the schools of the state government, and local authority means if we see this affiliation,
Yes.
then or local authority.
Yes.
So it falls within that. So it is in
Yes.
for one.
Yes. Local authority is defined, my lord, so in H.
In H it
Oh,
is
yes.
defined.
Yes.
Alright.
Yes.
It is not at all relevant.
No, it's.
Now to come to B.
Yes.
A school referred to subclause B.
Yes.
Subclause 2, clause N.
Yes.
2 is added school receiving grant in aid meets
Yes.
so and so as expenses of so and so
Yes.
to a RTE Act of the so and so.
Yes. So government school or an aided
That is
school?
it.
Yes.
So now what do you want to say now?
So what I want to say is this, Manoj, that two things emanate from guideline number 10. Two things. The first, that a central TET will apply only to the schools of the central government under 2(1)(a). Second, that as far as state governments are concerned when they conduct a TET, it applies to all the government schools and the aided schools within that state. That's why it uses the word the state.
What we are asking is
Yes.
where from you are reading within that state.
From the words, I'll just TET conducted by a state government shall apply to a school of the state government. So it is of that state government.
You are giving this because
Yes.
they may come with an argument. What
Yes.
may be their argument?
Their argument is based on the sentence after that, after the 1 and 2,
Yes.
that a school at 1 and 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with legislature. So that is what their argument is based on. That because of this guideline, we are entitled, therefore, to permit those who are called.
Yes, please.
Yes. It's not continuous. Yeah.
Yes.
And the next line after that, in case a state government UT with legislature decides not to conduct a TAT, a school at 1 and 2 in that state UT would consider the TET conducted by the central government. So, this is what is being relied upon by them to argue that we are entitled, therefore, to allow as a qualification a non-Jharkhand TET or a CTET. This is their argument. So now, the problem with that argument of theirs appears to be that it would require a twisting of section 23, which it is our submission is impermissible. I want your lordships to also see the rules under the RTE, which provide for how relaxation can be granted. This is completely This first sentence is what the High Court has relied on, my lord. So your lordship may mark that. That a school at 1 and 2 may also
You
consider.
are not disputing this situation. This NCT can issue a guideline.
We are not disputing that.
Not disputing.
Not disputing.
This guideline they have issued.
Yes.
While issuing this guideline, they
Yes.
have given one relaxation there.
Yes.
They have given this relaxation
Yes.
on which they are relying upon.
Yes.
And this is a relaxation. A school at 1 and 2
Yes.
may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with legislature.
Yes.
In case a state government UT with legislature decides not to conduct TET, a school at 1 and 2 in the state or UT would consider TET conducted by central government.
Second doesn't control.
So this is for central government and first is for the other states.
Yes.
So they have from other states,
Yes.
they have been permitted under this clause.
Yes.
So suppose then who would permit it? A school at 1 and 2.
Yes. The school itself.
So
Yes.
that can be permitted.
But that requires this procedure to be followed. That's what I'm showing your lordships. If you see the RTE rules made with reference to section 23, I'll just show your lordship. It's in the Bare Act itself. If your lordship takes a look.
Rule.
Rule 38. Sorry, 17. Rule 17. I'm sorry. Rule 17.
Minimum qualifications.
Rule 17 and 18, my lords. 17 says the central government shall within 1 month notify an academic authority for laying down minimum qualifications. So that's been done. Now at 18, relaxation of minimum qualifications. The state government and the union territory shall, within 6 months from the commencement of the Act, estimate teacher requirement as per norms in the schedule for all schools referred to in 2N. 2. Where a state government or a UT does not have adequate institutions offering courses or training in teacher education, or persons possessing minimum qualifications as notified in sub-rule 2 of Rule 17 are not available in sufficient numbers in relation to the requirement of teachers estimated under sub-rule 1, the state government or the union territory shall request, their only job is requesting, within 1 year of the commencement of the Act, the central government for relaxation of the prescribed minimum qualification. 3. On receipt of the request referred to in sub-rule 2.
Provision is made at the commencement of the Act because initially there was no institution, nothing.
That is correct. That is correct.
Not for subsequent period.
If that is so, then section 23(2).
That we will examine that your argument.
No, yes. So if my argument would be that while this is at the commencement, it would also apply in every situation where at some point either you don't have enough TET qualified candidates, you can't leave the children without any teachers. So then you need a relaxation for your state. So then you will write to them and say, please relax, I don't have enough TET qualified candidates. Or in a situation where, for example, some institutions are shut down, maybe because of Naxalism or anything else, and then you may be in such a situation. So if we were to read it that strictly to say that it's only within 1 year, then you're leaving the states without any other alternative, but to conjure up band-aid options.
Leave aside,
Yes.
direct questions.
Yes, sir.
The petitioners who were before the writ court,
Yes.
what was their relief before the High Court?
I'll just.
What they were asking the relief before the High Court?
Their prayers are at page 292 to 289 onwards. There are 4 prayers, and I'll read them. A. Why no steps were taken?
Just wait.
289 of the SL. 289 bottom.
Or showing for the respondent. So why the steps are not being taken to conduct the TET?
To conduct the TET since 2016, in spite of regular demands and protests, etc., etc. Then the second prayer, my lords, is at 292. How they will redress the aspirations of a large number of candidates available who have acquired all other requisite qualifications other than TET.
Prayer C.
Then prayer C, I'm reading all of them. Prayer C, for directing respondent 2 to either conduct TET in the light of Jharkhand test, etc., which mandates the state authorities to conduct the TET every year, or to consider ctet qualified candidates worthy for participating in the selection process of the teachers in the state. So there was an alternate prayer saying either you conduct it or allow ctet eligibility.
So these are the ctet persons.
Yes.
ctet persons.
Correct. They don't have a jtet. So they have a ctet which permits them to apply for teacher positions in all central government institutions. So they have that. They therefore are asking for jtet equivalence as well. We don't have the ctet option. We have only our Jharkhand option. These are the prayers. Now, when this comes up before the High Court, at page 9 is where the judgment starts.
It's random.
It's mentioned, yeah, this supplement. If I can just see para 2, para 2, which is at the bottom of page 9. Bottom of page 9. The matter was heard by us, and in course of hearing on 25th July, our attention was drawn to clause 10 of the guidelines conducting TET, what I just read to your lordship.
So meaning whereby we see
Yes.
then this guideline applicability,
Yes.
then the later part of this B,
Yes.
later part of this B,
Yes. Later part of this B.
in case the state government UT with legislature decides
Not to conduct
not
the
to
TET.
conduct a TET,
A school at 1 and 2 would consider the TET conducted by the central government. So the prayer is only about ctet.
a school of 1 and 2 in the
Yes.
state, in that state would consider the TET.
Correct. So clearly for this to apply, the state needs to take a stand that we are not going to conduct TET. Once the state says we won't conduct the TET, then obviously it's very fair for them to get the ctet qualified candidates and ask them also to take part. State has not taken such a stand. That's not the state stand even today. On the contrary, the state has in its counter affidavit said that we will be conducting the TET. They are conducting the TET.
Anyway. Now come to the
Yes, ma'am. Now, if you just see para 4,
para 4.
Para 4, this is the stand that they've taken.
Supplementary counter affidavit.
Yes, supplementary counter affidavit. Just see extracted para 8. There.
Yes.
That it is stated and submitted that state of Jharkhand is intending to implement jtet objectives in consonance with the geographical and regional needs, requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. This is their evidence stand. So therefore, that guideline 10 won't kick in because they will conduct the exam and they will keep in mind culture, language, tribals, etc., etc. Now, para 6.
Yes.
Para 6. However, in course of hearing of these writ petitions today, learned Advocate General appearing for the state would submit that he has received oral instructions that the state is willing to relax the criteria for eligibility as far as the candidates having ctet examination certificate, with a stipulation that in a future date they have to clear the state TET examination and those persons should be the residents of Jharkhand. This is what we are aggrieved by because we don't believe the state could possibly relax. The state did not have this authority. The only exception is if the state took a decision saying we are not going to conduct the TET. The supplementary counter affidavit makes it clear that they will. I can continue. Since the law provides that every year there should be a TET examination, and for the last so many years there has been no examination for testing the eligibility of aspirants to be appointed as teachers, we are of the opinion that not only those candidates who have ctet certificate and residents of Jharkhand, but also those residents of Jharkhand having other qualification and having state TET examination certificate of any of the neighboring states shall also be given a chance to appear.
So they have taken both clauses.
Yes.
Of that applicable.
Correct. When it was not even a prayer. Your lordship would notice the prayer was for ctet and the alternative, not for any other state's qualification. They widened it. Having other qualification and having state TET examination certificate of any of the neighboring states should also be given a chance to appear in the examination with certain stipulations which we propose laid down in the following paragraphs. In view of the proposal made by the learned AG and also having considered the matter to a great extent perhaps, we hereby dispose of the writ petitions and the PIL directing the state government to conduct the TET examination every year henceforth.
That's all right. It's not the
That's so
eligibility.
correct. So para 8, we further, sorry.
So whether the High Court has considered this clause?
No, they've only
It is
considered this.
in para 2. Para 2 it is considered.
Correct.
The
Clause
guideline,
10.
the guideline clause. It's,
Considered.
that's
Matter was
one.
heard
Clause
here.
10. Clause 10, nothing
Our
else.
attention was drawn by clause 10 to the guideline of TET.
Yes,
It has been by subclause B.
correct,
The school referred subclause 1 and 2.
correct.
Eligibility of the candidate who have obtained the TET certificate awarded by another state is so and so. In case there is a quoted and a
Correct, that's all quoted. That's
view of such position, we are of the opinion the state government is genuinely creating a number of posts
yes.
for which the state TET examination is required to be conducted.
So what they've
It has
not,
not been held for the last almost 9 years.
yes. No, but he's
Last examination was held in 2016. should
Yes.
not take into consideration the provision. Therefore, they advise the Resident Council for the state
Yes.
whether they intend to allow these candidates who have AT examination. Okay.
Now, this has to be, if your lordship just see now the directions at paras 8 and 9. These are where the errors creep in. Para 8 is page 12. We further direct that those residents of the state of Jharkhand who are otherwise eligible to appear in the examination and hold a ctet certificate or a certificate issued by neighboring states having resident of Jharkhand shall be allowed to appear in the ongoing process, which has already started, with a further stipulation that the state shall ensure that the examination, if not held within a year, is held at least within next 3 years. Now, this is itself self-contradictory. If you're holding the exam, as per the guidelines, there can't be ctet. It's only if you're not holding the exam that you can have a ctet. And the candidates who have participated in the selection process and have been appointed have to clear that ctet examination within a period of 3 years by giving one chance. They shall pass it within 3 years and in one first available chance. So this is the first direction. The second, we further stipulate that the state government shall not conduct the examination at least for next 3 months, so that the candidates should get some time to get ready.
It may not be that relevant.
It may not be. I mean, but all this was completely unnecessary when you have 1 lakh candidates who are eligible and available.
Where is that 1 lakh candidates have been had?
It's admitted in their counter of the state, my lords. Just give me page number. Para page. Counter in the Supreme Court.
It was not there in the High Court.
There's a counter in the High Court, supplementary counter in the High Court.
Where is that?
Counter
It is pleaded.
Para page. No, numbers. What numbers?
Supplementary in Supreme Court.
The numbers I understand are only in the Supreme Court counter affidavit.
Well, where is that? Where you pleaded that?
That if you just see the Supreme Court counter,
No, where you have pleaded it. You have to show somewhere your pleading.
we have come to the Supreme Court, no? So
In your pleading, it has to be there. Then only the counter will come in.
no,
You have to state something.
we came for the first time in the Supreme Court, so it's only from Supreme Court pleadings I can show you.
What is the question is being come to you here?
Yes, Lord.
In Supreme Court writ petition which you have filed,
Yeah, SLP, yes.
you must have asserted here that how many candidates have appeared.
Page
Therefore, adequate number of the candidates were available to participate.
Page
Those possessing a TET from those are having the JTET.
page H, my lords.
Page H.
H. Page H.
There is no reply given to the list of dates.
Where is the
Sorry, ma'am?
pleading?
Ground, you come to page 213.
No. So I on that, if your lordships looks at the certificate that we annex at the end of every SLP, the certificate is an attestation by the advocate and record in these courts that the SLP synopsis, list of dates, all form one single composite. So when replies are filed, they're filed, but it's there in the grounds also. I'll show you both. I'll show you both.
Leave aside what certificates are given.
No, I'm
Don't
just
argue
telling-
that.
Yes.
We can show you hundreds of wrong, incorrect certificates.
Just see ground L in the SLP.
That I've told you 213 page it is there.
Yes.
Now see the counter. Let us see the counter.
States counter, my Page 13, my lords, of the states counter. That's counter on behalf of respondents 1 to 5.
Page 13.
1, 3. Para 8. In the peculiar facts and
Page 13.
Page 13, yes, my lords, of their counter. Para 8.
Yes.
In the peculiar facts and circumstances of the present case, wherein the regular jtet could not be conducted in the past few years due to COVID pandemic and other contingencies, and on one hand, there are enough members of jtet qualified candidates within the state, approximately 1 lakh. Whereas on the other hand, a large number of ctet qualified candidates and residents of state of Jharkhand who are aspiring to participate in the process of appointment. So here also they admit there's about 1 lakh of us. And they say there are enough numbers. So they also believe there's satisfaction as far as quantity is concerned.
So now what is your argument finally?
So my arguments, the Lordship can just pick up this note that sums up what my arguments are after the list of dates, page 2. The first is that section 23 is mandatory. And those relaxations can only be by the central government following the procedure that's been provided.
4.2.
Yes, Manoj. 4.1 makes it clear that section 23 is mandatory. 4.2 talks about how relaxation can be only by the central government. And as your lordships have seen, that guidelines itself provides that ctet is only for central government schools, not for anything else. The only thing in the guidelines which your lordships noticed is that they say if the state says we're not going to conduct the TET, then the question may arise of you borrowing and using ctet qualified candidates. But that trigger, even as per the guidelines, admittedly is not there, because as we have shown you from the counter, their stand is we are conducting the exam. And again, in this counter just now, the same paragraph, they have said that we will be conducting, we couldn't conduct it because of COVID and other circumstances. So they have never taken a stand which fulfills that guideline 10 second part, which requires them to say that we will not conduct that, in which case, yes, ctet can be borrowed. So that even we are not saying that you can't if you're not conducting the exam. We are saying since you have said that you are conducting the exam, then you have to strictly go by jtet.
Basically, 23.2 compliance is your answer.
Yes, 23.2 along with the guideline itself. Even if I
guidelines following the rules.
Following throughout.
Following the rules.
Yes. Now, there's one couple of additional points. If you see 4.3 and 4.4 at page 3, we've given the page references. Service importance of TET cannot be overemphasized and has been accepted by the state. 4.3, Manoj, page 3. Service rules provide that TET papers include tribal and regional languages. Jharkhand, being a tribal state with 32 scheduled tribes, requires regional language as a medium of communication with students. Jharkhand also has the third lowest literacy rate in India. Further, the state itself has admitted before the High Court that ctet does not fulfill the needs of the state to the state regional language and local needs. This is at page 302. The Lordship will find it in para 12. This is what they've said. It's part of the supplementary counter that they filed in the High Court.
Main counter.
Sorry, it's main counter, not supplementary, main counter. Part of the main counter.
All right.
Yes. And the other ground is on prejudice, Malad. I've mentioned that. And finally, in the directions, if your lordships notice, they don't say that certificates of TET from any states. They say neighboring states. There's no rationale really behind any of this. They shouldn't have departed from what the requirements are, what the qualifications are when they admit that 1 lakh are available.
If relaxation is good, then that clause is good. That proviso, if it is bad, it is bad.
It is bad. I'm grateful. That's all
I think maybe in this speaking they may have thought of, we don't know, but
that's
I think state heavy.
Left to the local.
Maybe.
But there's a companion petition.
Yes.
Wait, please.
That is all.
Yes, madam.
Yes, madam.
Wait, please, madam. Now, while you are on the counter filed by the state, which has been partly dealt with by the impugned order, would your lordship kindly see just 2 paragraphs of the counter filed by the state, which is very relevant.
To counter file in this Supreme Court and High Court.
Yes, my lord. Please come to page number 323 of the same paper book which Mr. Gopal had referred to. 323. The reasons, because the High Court talks about 10. It doesn't talk about what the state itself was concerned about. Please come to para 18, page 323, Manoj. That it is further stated that the central TET qualified candidate or a candidate qualifying TET by another state can only be considered for a state-run schools when particular state government has decided not to conduct its own TET. But it is most humbly stated that it is not the case that the state government had decided not to conduct the JTET, and in these circumstances, the state government is not bound to consider central TET or a candidate qualifying TET by another state or UT as eligible qualifications. that CTET qualified candidates can be made eligible in a given contingency where the state government is not conducting TET, but when this contingency does not exist, there is no occasion to make central TET candidates eligible or to allow those candidates who have obtained TET from central government or any other state UT. Lord, in this scenario,
So your contention is
yes,
that in the first counter affidavit filed before the High Court,
this is the second counter, supplementary counter.
this supplementary counter.
Yes, this is supplementary. Subsequent to, my lord, the first.
Then suppose the supplementary counter says this.
Yes.
Then from where this concession has come?
This is oral, my lord. It is just the Advocate General says oral concession. There is nothing in writing. Number one.
All right, statement of Advocate General is.
Therefore, they have taken it. Number two, my lord. The entire writ petition, my lord, is allegedly it's called as a PIL. In service law, there is no PIL. In fact, all the petitioners are wanting to participate in this election. It's not a PIL in that sense. They are an unregistered association. We do not know how many members are there. They came before the High Court, my lord. The Honorable High Court ought to have at least seen all these provisions, which my learned friend was now striving to point out, my lord. What are the statutory sequence? What are the regulations to be applied? Whether it can be relaxed at this point of time, whether the contentions of the petitioner only for the prayer that please conduct JET, which can be at a stretch, we are saying that in the upcoming selection, please consider me. Now, please note the point, my lord. The rules in existence on that date had only JTET. When they went to the writ court, there was no challenge to the rules in existence. They said the rules in existence, when we participated in the advertisement said only JTET. There is no challenge to that. In that scenario, whether the High Court would have rewritten the rule or the advertisement, your lordships have held, my lord, you can't change the rules after the game has started. As simple as that.
Where are the rules, Madam?
Yes, so, my friend had pointed out 228.
234.
No, it started like that, no, but the relevant portion.
228 at 234.
Yes. $240. Please come to 240 and also
34 is
240, also 242. Yes, for primary. 240.
240.
Yeah, I'll first show 237, it starts. Thank you. But the peculiarity of the state is so much that they take so much into consideration, Lord. They belong to various tribes and therefore it's very important. The state had itself pointed out all those. 237, Lord. Para 3E. E is there, middle of the page.
So you are as 228.
Which is
228.
Yes, Lord. It started at 228, Lord. Kindly come to 234, which will say qualification. Correct. Yes.
234.
Yes, sir. We'll start with qualification. 234 will start with qualification.
Yes.
Please come to 237, Milord. Middle of the page. Yes. Left side will be, Milord, intermediate teacher, education, what is that, all rules of mathematics, physics, etc. Coming to the 237 middle, 3E. Candidates will be eligible for appointment as assistant teacher in the same subject group in which they have passed.
Subject is all right. We have to see JET.
Yes, please come over the page, Milord.
Page 248.
240, absolutely, Lord. I'm great.
20 years left.
JTET.
From the qualification.
You must read this last part.
Yes, Lord. Why I wanted to read this 237 was the point which we were stressing that, Lord. Same subject in which they have passed the teacher eligibility test, and after passing the teacher eligibility test in the regional language, tribal language, notified for the district, will be eligible for appointment in that particular district.
No, the advertisement is district wise.
Yes.
Yes.
Is advertisement district wise?
Post, sir. Because suppose somebody has learned Santalia, then they will be posted in that district.
Let us see the advertisement.
Yes. Advertisement.
I will see. Go back. Please first complete this.
All right, I'll complete. At 240 minutes. At 240. State.
240.
Clarify that. 240B and passed in JTET. the teacher eligibility test conducted for classes 1 to 5 and 6 to 8 by the government of Jharkhand under the guidelines formulated by NCTE. Yeah, correct. 240.
Now come to that advertisement.
42 also, it says 6 to 8 JTET. Yes.
It's not 6 to 8.
Yes. Both are not 1 to 5 and 6 to 8 are primary and upper primary. Please come to the advertisement.
Advertisement.
Yeah. Just one more, 2 lines in that advertisement itself at 238 on top, Milord. Sorry, on the rules itself. On top, Milord. Just 2 lines.
238.
238. On top, first line. 238.
Yes.
It will be mandatory to have knowledge of local customs, language and environment. Yes.
They are basically, they say, residents of Jharkhand only.
But ctet is only English, Milord. They don't have all these languages.
That's a different thing.
Very well. No, that's very
But they have
essential
the
for a
knowledge of-
primary child. In fact, Devesh
They have
Sharma, your
knowledge of all this. That's why they said residents of Jharkhand only.
residence is fine, Lord, but they didn't pass. Lord, we had passed in 16, waiting for the past 8 years. And different local customs and languages and tribal. Yeah. Advertisement will be in the additional documents, Lord. Your lordships have seen it. There also at one, yeah, it is starting at 35, but relevant portion of qualification 51.
51.
51.
Additional.
The same volume which your lordships were seeing earlier also.
51.
Additional
But 51 will show district-wise reserved post for non-para.
non-para. You are non-para.
Non-para, we are all non-para.
Even para is district.
Yes, everybody is district-wise only, but this is specially for non-para. Then come to 142.
So as per you, it is district wise, no?
Yes, my lord.
And then
After this,
after qualifying the test,
yes.
then at that time they may look into about this.
Which district, which posting.
Accordingly,
Yes,
they may do it.
yes, my lord, rank wise. 142, your lordship will find the same advertisement in pursuance of these rules, which contained JTET, your lordship saw it, my lord. Page 142, your lordships had seen in
JTET.
JTET.
The test password to
Yes,
by
by the government of Jharkhand is the advertisement also.
But in that test, they are taking test of all the languages and all that of the state.
Every detail. This one, my lord. In this advertisement, they.
No, the question is different.
Sorry.
In JTET, when he is appearing, the person is appearing in JTET.
Yes.
So when he appears in a JTET, then what is the curriculum? That are they taking the test of language-wise and everything?
Particular language. They choose a language. Particular tribal
He will-
areas.
he will be eligible.
Language.
But
That
how
is
will
why
he-
they get an extra advantage.
Who he will be eligible for appointment in another district.
He will not be, He will be chosen when he comes in the merit list according to his.
Suppose
Will
he
it
comes
in the
in-
advertisement some preference in the form have been prescribed?
The advertisement will show that yes,
Any
the post
preference?
are reserved for a particular tribe.
In the rules,
Yes.
tribal and regional language, anyone who
Page 246 will show. Self. The subjects are given at 246. Language is essential. List language, mother tongue, and gender knowledge. They are common, my lord.
Where you are reading?
246 of the SLP, which is the rule as such, my lord. Your lordships will get that.
Rules are for appointment.
No, rules mention that every person for this examination, what should be the subject matter is
What are
written
the
there. Marks allotted for that.
Approved by Jharkhand Academic Council, so the format of examination will be
But will be serial number A will be subject is tribal and regional language. Any one of the district-wise languages notified with a notification so and so.
There are 32
But
languages.
yes,
There are 32.
there are 32. The question is 70 marks maximum. Then your lordship will be any one of the mother tongue as per secondary examination. Then my lord C is general knowledge, current affairs, social science, and that's it, mathematics.
This is the test for this selection.
Yes.
We are asking for the syllabus for JTET.
Yes, Lord. This is assistant teacher.
Yes.
Yes.
The question which was put before
Yeah.
was that for the purpose of the jtet, then to appear for a jtet,
Yes.
is it district-wise, language-wise, regional language-wise?
We are instructed to state it language-wise. We don't have the ready reference of the rules here.
We do.
Yeah, you
It's
have
the states counter.
state counter. Sorry.
States counter in the Supreme Court at page 21 are the rules, and the list of languages are at page 21 at 31
Yes.
of the counter of the state.
Yes.
Page 21, Manoj, is where it starts.
Sorry.
Yes, please.
This is the notification.
Yes, Manoj. So this is the
jtet test.
yes. So these are the TET rules, Manoj, for Jharkhand.
Yes.
His Lordship just comes to page 31.
31.
This is the district-wise. This is a schedule. District-wise list of tribal regional languages, which is listed.
No,
That is there. Where is
that
the
is fine.
syllabus?
What we are asking, Mr. Gopal Shankar Narayan and Ma'am
Yes.
Manaji, what we are asking is, schedule is in terms of the rules. So where is this description in the rule? That's how this appointment would be in that. You are specifying this district contained with this language and so and so. A
Yes.
different thing.
Yes.
So where it is prescribed, number one,
Yes.
for jtet curriculum, the person has to appear in this regional languages, and those persons as per have a preference under the rules in so and so, and option is required for their appointment in this regard.
So page 28 of this same, just if you go a little way back, 28. At 27, they give the pattern of the eligibility test. At 28, after the table ends, Manoj, just see G. Sorry, not G. I.
Regional travel language mentioned.
Mentioned under language 2 in rule 7 will be as per schedule 1 of the rules. For appointment to the post of teacher, the candidate will have to take the examination in any one of the regional tribal languages allowed for the district applied. So in the schedule, they give for each district what those languages are.
District.
And then,
No. District applied. That means he'll be eligible only for that district.
Yes.
as per this, yes.
So
No,
please
this is
clarify
only
this
JT.
situation.
Yes.
It is not going to complete today.
Very well.
We are seeing.
Yes.
To clarify and relevant rules of that, people pointed rules. So
Right.
this is a rule for appointment. Rule says this month.
Right.
So and so far as curriculum
Yes.
for that jtet is concerned.
Yes.
Alright. So what prescribes so? Please clear, make it clear to
We'll
them.
do that. We'll do
We're
that.
not going to complete today. We have understand now.
Lord, the certificate mentions the language that he has studied specifically. The TET certificate issued to the candidates mention only what he has chosen, and only he will be considered for that. We'll
Yeah,
place
but
that.
here in this case, we are considering the rule part.
Yes.
But for the rule part, we want some support of
We'll
factual background.
give it.
We know this. We
We'll-
want to
Yes,
know.
Understood.
Yes. All that happened because of the shortest order, Milord. Therefore, nothing was considered therein.
Yes, all right.
In fact, Milord, your Lordship will see.
Now you go on by your argument, ma'am.
Yes, thank you. But this, we are not 1,301 people who qualified in 2016 in the JTET, and we have been waiting since 2016, Lord. Your Lordship will see that I showed that the rules in existence framed under 309 has considered this, Lord.
Ma'am, you passed out JT18 in 2016. After passing out of JT18 in 2016, this notification of the teacher's recruitment is of 2023.
Never came.
During this period, any other advertisement was issued?
No, we have been waiting.
There was no
Lord.
advertisement.
We have conducted protests and dharnas for selection.
Advertisement. 7 years to wait.
So many,
For recruitment, no advertisement.
no recruitment there. We
We'll ask-
have been waiting
We'll
for
ask
so
the
long.
state council.
2016 onward. That is why, my Lord.
Which is why they also didn't conduct another JTET.
No, we
Because
can't.
of unemployment, the school colleges have not been closed.
Don't take the anything, which is not a part of the either counter affidavit or on the
would be the
no.
would be the reasonable thing because
No,
you have
you don't get lot list, right?
I have lots of people
No,
doing
Mr.
exams and sitting.
No.
Next.
They have not closed the normal graduation, post-graduation or any other school colleges because employment is not there.
No. Next is in the advertisement. The advertisement specifies there is a deadline to the advertisement. The deadline for applying and also
That is-
acquiring qualification also.
Has to be there on that.
Deadline to the advertisement.
No,
Therefore,
for the purpose of
applying for
you
this.
must have purchased this degree on or before so and so date.
Yes, my lord.
Please show that.
Yes. Please come to 142.
142.
Is that qualification? But at 149. 149.
Please, 149.
Yes, my lord. Minimum educational qualifications. 160.
Yes, please. It will be mandatory for the candidate who have purchased the desired minimum qualification.
60.
Last date is the application of the commission.
Yes, that will be at 169 also. The reference date is the last date. Please come to the last date at 169, my lord.
Always the last date for filing application.
Yes, para
Yes,
15
otherwise-
at 169.
Para
Para 15, 15.
169.
169, my lord. For registration and entering information from 8/8/23 to midnight 7/9/23 to pay the examination fees on.
Not relevant. You tell us the.
No, you know,
This already
what
there
I'm
on
trying
the-
to point out is that all the qualifications ought to have been attained on that day. The Honorable High Court while entertaining,
Always there in all cases.
That
but
is-
the High Court while entertaining the writ petition, there was no stay or
And
that.
Annaji, don't come argue. Please come to 149.1.
Yes.
Last 3 lines.
Yes, my lord. Yes,
If
my lord.
any candidate does not possess the prescribed educational qualification by this date,
Exactly.
so you say read this much. Why you are arguing here?
Last date.
I'm obliged. Not will.
Considered ineligible for the application form.
Yes, this is our.
Read this now.
Yes,
That is required.
yes, my lord.
Going here and there.
This is.
Because last cutoff date is there.
Yes, yes. The cutoff date is there, and this
So
is
the cutoff date shall be ineligible. Now
Yes.
we are asking one thing.
Yes,
This is in the advertisement.
yes,
Something like this
yes.
has been prescribed in the rules.
About this last date.
Ma'am, please. There are 2 different things. If rule prescribes something like the UPSC rules, on that date you must possess this much. You cannot deviate from that.
I'll just get it verified. But you know what happens is each advertisement is special, and the dates mentioned therein will be only relevant to that particular selection. So the dates cut off.
Like that.
Yes,
What we are saying, the rule must say that the persons must possess a qualification,
yes,
okay, on the last date of filling of the form. That would be fine.
yes,
We can understand the UPSC rules prescribe so,
yes.
and then they cannot change any qualification of any type.
Just check 2, 3.
Is it something in the rules?
I'll just get it checked. I'll just come back to you on that.
Check it, madam. What is your next argument?
Yes. Now again, not I was submitting on this point that not the rules have been changed midway. None of this. I was just trying to submit.
So your argument was, I will brief you. Rules were like this. Under these rules, this is prescribed. They were not possessing a prescribed in the rules. So once they are challenging the advertisement, asking some benefit by filing a writ petition through an association, in that situation, they must have challenged the rules and asked the qualification in terms of provisions of this act,
Yes.
and accordingly the court may have allowed.
Yes.
So in the present case, nothing like that is followed. So that is your argument.
Yes, Lord.
Anything else we have rightly understood?
Yes, Lord. Of course, Lord, and the advertisement also. So therefore, Lord, in the other limb of the argument, as a jtet passed candidate from 2016 waiting eagerly for this selection, I had a legitimate expectation that I will be considered as per the existing rules. Of course, in service now, Lord, your Lordship will point out, and I am aware that nobody has a vested right to be appointed or but Lord, I have a right to be considered. I have a right to be considered as per the existing rules and the advertisement, Lord. That right I have.
Here it is a case, the right to participate.
Yes, and to participate, Lord.
Participate in the test.
Yes, participate.
Right to participate in the test.
As
Not
per
more than that.
No, Existing rules.
Not considered. Considered would come after you qualify that. Then it will come.
That's what I am seeking, Lord. Therefore, there is a legitimate expectation that I will be considered as per the existing rules, and advertisement is my submission. So therefore, the rules. So there is next, Lord. That now the state, after the judgment of the Honorable High Court, have now tried to amend the rule, Lord. After the advertisement, after everything, they have now amended the rules in 23 to say that ctet can be considered as one of the eligibility conditions. That I'm bringing to your Lordship's notice, because we had filed an additional affidavit pointing out that this couldn't have been done at this juncture because of the judgment. So therefore, again, the rules of the game is being sought to be changed after the process had begun, which is impermissible in law.
The same argument would apply to you also.
Yes.
No.
No.
What argument you want to say for them?
Yes. That the rules
They have to challenge. So now the amendment you have to challenge.
We have
argument applies
for this honorable court note. We have filed an additional application challenging that here because the matter is pending before your Lordship.
No, we can't do anything here.
This is anyway.
We can't do anything on the basis of an application. We can't examine this.
My argument. This cannot apply to me in the present selection. To them in the present selection.
You can ask this much.
Yes.
You can ask this much.
Yes. Yeah, that's what we are pointing out. That's what we are pointing out, my lord. So they cannot take that as an argument to consider ctet, saying that I have now today amended the rules. That is what I am trying to say. Yes, my lord. And my lord, every state has been given power to.
Let us understand one aspect of it.
Yes.
Advertisement was issued.
Yes.
They doesn't possess the qualification.
Yes.
Relaxation was not allowed to them.
Yes.
How they have filled up their forms?
High Court order. After the High Court.
This was before.
So after the we want
after the cutoff date. Yes.
Madam, we want the date, the chronology of the dates.
Yes.
Advertisement issued.
Yes. They have fixed given.
Please clear. We are not interested in hurry in deciding the cases because we know. So advertisement was issued.
Yes.
When it was challenged then. What was the last date of filling of the form was?
The writ petition was filed on 18th.
No, last date.
Last date? September.
Last date of filling of the form was?
September.
Which date?
September 23.
Yes, my lord. 7th September.
7. When the writ petition was filed?
It was filed. I don't know the date. Any incorrect date will be modification is 30. Last date, yes. Sorry. 18th May 23.
18th.
Writ was filed.
What is the date of advertisement? August. It can't be filed in May. And that means it was filed before that.
Okay. Advertisement is July 23. We don't know the exact date because it doesn't mention the date.
Mentioned August only in this.
So you please.
Because the writ doesn't challenge the advertisement.
Yeah, nothing is challenged.
Writ is you saw 3 prayers. They just want to be considered. They might have known whether the advertisement is coming or not.
It is prior to the advertisement.
And they didn't amend it thereafter. It is prior to advertisement. They didn't amend it.
But as on the date of the advertisement, the rules were still applying.
So what is the date of the advertisement?
Yes, my lord.
Date of advertisement was?
Able to say July 23 is what it says, my lord. The date is not there, my lord, actually.
July or August? We have August.
Yes.
It doesn't say actually.
Advertisement doesn't give any month, my lord. It's either July or August, and my dates have put August. Miss Mona is saying July. State will give you the date.
State can give
you the date.
Advertisement always has a date on that.
No, unfortunately, it doesn't mention.
Then they should start giving. I'm being instructed to say Jharkhand mein nahi dete. I don't think that can be
Very peculiar.
You can say. At present, we can't say.
Not bearing on this side.
So they'll be having a date for it.
They must have a date of it.
Date must be there or when it was published in the newspaper.
19 July.
19 July.
Because when it is published in the newspaper, basically.
And when you receive this notice of writ petition?
State received.
Counter was filed in less than a month. Counter was filed. Your lordships asked when was the notice received?
Counter is filed on 18 June.
25/6.
25 June.
25/6 counter filed.
25 June, one counter.
Those 2 dates.
14th August, supplementary counter.
Between those 2 dates, between May 23 and
May,
June 25 is the counter.
May is the repetition date.
18th May and 20.
So, our thought process is
Counter says
you
22.
issued an advertisement after filing your counter affidavit. And after serving the notice.
Yes.
Notice was served to you
Yes,
already.
yes.
And thereafter you issued this advertisement.
Yes.
Anyway, we will ask the questions whenever you will argue. You are for the state, Mr.
Yes, Mr. Manar.
In the first matter, I am assisting your lordship for
For
the.
state.
Yes.
And you are for
the state in the second man.
second matter. All right.
Are you
The double engine. You are
Double barrel gun.
candidates.
ctet and the
Triple engine. All right.
Not out of the two petitions.
Yes, ma'am. Now this argument is over.
Yes.
Now what is next argument?
Just one more point. Just in the beginning also I mentioned, this was not a PIL, number one. This was a personal litigation only. It can't be mentioned or treated as a PIL because they were interested candidates who wanted to participate. They were,
For the petitioners.
sorry, yes,
For the petitioner. Association or some petitioner.
association and one individual, Today, interestingly, the individual who filed the writ also filed a counter here, has already got an employment in the KV based on his CTET and he is joined there. The candidate who has filed a counter here and who was a petitioner there,
CTET, Uttiran Abhiyar.
who have an edge, because, sorry,
Petitioner number name I have.
Yes.
Jharkhandi, CTET, Uttiran Abhiyar, son.
Yes. It's an unregistered association and we do not know how many people are there, what is their qualification when they acquired it.
Right.
None of
They are
them
not
available.
getting any employment on that.
I'm just saying that, that
Like
it's never treated as
another
a public-
aspect which we are asking you,
Yes.
then suppose, then in this case some interim orders were passed by the High Court.
No, that's what I was coming to, Lord. There was no interim order.
So then how they have applied?
Not only based after the writ petition, Lord.
Allowing. What is the date of that impugned judgment?
Impugned judgment is 20/12/23.
Last date was expired.
Yes. In September 7th.
But
On September.
there are other writ petitions also.
No,
Yes, just see page 1.
they were all over on that day.
No, there were other writ petitions also before the High Court. It's not one only.
That your lordship said
All
same for
there
my
in that.
petitioner.
Yes, so what was in that?
They were all same judgment. They were all dealt
Judgment is
with.
same, but there were other writ petitions also. Number of parties. In
Yes.
one, there were 308 petitioners.
Prayer same for everybody.
That's right, but what was the prayer? What was they were local candidates, CTET or JTT.
They are all CTET is what they say.
But
But
what was
we
the
can't say we can't understand this like this.
prayer?
Because this is by association,
Yes.
CTET, whatever it is. Now, anyway, let us understand
Yes.
that the judgment was passed on 2023.
Yes. There was no extension of time or anything by the High Court.
There are number of the writ petitions filed, number of the persons were there.
That's very common.
Maybe they are.
Yes.
But what is the relief in that?
Can't see.
You please clarify this by tomorrow.
Yes, 1 second, Lord.
We have to ask another thing.
One.
Whether in any of the case, please note down.
Yes.
In any of the case, any order was passed that they be permitted to fill up their forms.
In between. No, my lords.
They were not permitted by the High Court to.
Extension of date. Nothing
Then-
was permitted.
Just after this judgment,
Yes.
prior to that, last date was September
Yes.
23.
Yes.
Then after this judgment, any corrigendum was issued to fill up,
On 10th of January 24,
which is not mentioned in this list of dates. No?
I've got it in my
In this.
dates.
No, it's not.
Sorry, I've got it.
This must be complete, Mr. Gopal.
Subsequent events are not put. I should.
You have to put everything. Here.
Can I give
Nothing
mine so that-
subsequent, it is all before the date of hearing.
No, that is correct. I'll revise it and give it to you tomorrow.
No, it's here. Or I can give the dates.
So if you have to.
20th December is the judgment.
So then January judgment was issued.
It's there on record, my lord, in the additional documents at page 267. Additional documents, page 267. There is a notification dated 10th of January 2020. 267. All the cases are mentioned there. Lordships got it, not 267.
267 of SLP.
Lord, the additional documents which you were seeing, the advertisement, etc.
Expanding the date.
Yes, my lord. In complaint on the judgment of so and so passed by the Honorable Jharkhand High Court in a petition so and so by the ctet passed candidates association, Surat Bihari so and so. In these cases, the local residents of Jharkhand state who have passed ctet or DET from the neighboring state and who are willing to appear in the Jharkhand primary school trained assistant teacher joint competitive examination 23 online applications for the above examinations are invited. For inviting applications from the above mentioned type of persons is being activated soon on the website of the commission. Also, in the light of the above order, rescheduling of the examination schedule of Jharkhand Elementary School Trained Assistant Teacher Joint Competitive Examination 23 to be held from...
What was the last date extended? There is no date finally given.
This is all. We don't know further any notification. It's not on record.
Any comments from Mr. Gopal Shankar Narayan?
Gopal, was it further extended? He's asked. We are not aware.
This is also the practice that no last date is given.
We have
The exam was held down.
What is only the exam scheduled?
exam
Cut-off date now.
exam was held on a series of dates through.
We have only asked that what is the last date after extension to submit application. Is there that in all?
Kindly see 269, 270.
10 February.
269, 270. Please see, kindly see over the page, not at 270. That is only for the disabled candidates. That's all. Attached prescribed form to the commission. Application submitted after the period will not be considered by the commission. And the concerned
Disabled?
Yes, that's all. So therefore, we assume that it has to be before this date for everybody.
There is a date of last date of submission.
This is what...
Not there.
Even, no.
It is only invited. Everyone invited.
Yes, Lord.
Open.
Open
Date is announced by them.
Come with a certificate and the examination center, all right.
I find it in 270 of additional documents.
270.
270 is from
Disabled
candidates.
I just pointed out.
There are 269.
Disabled category candidates submitted valid online
Yes,
applications.
I just pointed out that. Then we not rules get amended.
Nothing.
Even this doesn't relax. Then there comes the rule next, 29th of January 24.
Application attest prescribed from commission from application submitted after said period.
Yes.
Considered by the commission, concerned candidate will have to be searched.
Yes.
For the convenience. So it is not for both examination. No? This is only various centers located in these.
Simply able category. Because page 267 is only showing that the date of test is now pre-posted.
Fixed now, yes. And others.
It's not for extension of time for submission
No,
of
it
application.
doesn't say so in that language. Not all it says is you also apply now. If your Lordship may say online applications are invited, it says. For inviting, we are opening the website, is what it says.
Please give this all clarity with the dates.
We have we also have, yes.
Then do it in clear. Then what is your next argument, ma'am?
Yes, your Lordship will see this, the last point, I'll show it and close it. Not the rules have been amended. That portion would your Lordship like to see.
Here is that
It's filed along with the counter.
counter by the central
State.
page number 60.
29th January.
Yes, my Lord.
We have amended.
Yes. In exercise of powers so and so, governor of so and so, amendment. The rules 22. Amendment Rules 23 as amended, and following amendments are made in the Rules of 23 constituted for appointment, promotion.
But this is prior to the last date of that candidate's
No,
advertisement was.
no, my lord.
This rules amendment,
This is
29 January. In that case, 30th January. We have to understand this relevance, huh?
The rules shall be.
Cut-off date.
Kindly see, my lord. Kindly come to see. Commencement, short name, extent, and commencement.
Page number
The rules are that's the same page 60 itself.
60 years.
These rules are called as, shall be called as Jharkhand Primary School Sahayak and so on, so my lord. 24, its extension so on. So these rules shall be effective from the date of issuance of notification.
That's all right. The cutoff date now for submission of application is after this.
10-2. 10-2.
So whether these will be applicable or not.
In our submission, it will not be.
Oh, your submission may be, but it must be supported by law, no? Because this is prior to that cut-off date.
Cut-off date extension itself is questionable only because of the judgment, because we are challenging the judgment itself, whether it is applicable or not for them. Secondly, my lord, that they cannot change the rules once the process itself has started. So therefore, whether they could withstand that is another question.
Now, where is that provision regarding this in this amended rules?
Yes, 60,
Where we have to see?
63,
Page 63.
Rule 6.
Assistant teacher appointment and so qualified teacher
Rule 6.
jtet conducted in Jharkhand under the so and so qualified.
In addition, qualified teachers jtet, then we not in addition to the above, such residents of the state of Jharkhand who have qualified ctet conducted for class 1 to 5 under the guiding principles formulated by the NCT or qualified in the TET by the neighboring states of Jharkhand are included. There also it doesn't say. In the appointment procedure on the post of assistant teacher, subject to this condition that it shall be mandatory for them to qualify jtet in the chance available within and before 3 years after the appointment.
As was the initial condition initially there to follow.
In the judgment. And para 7 also.
Not judgment, the rules also provided that. But then
That's
they said
initial,
change the rules.
yes. Yes. Rule 7 is for the next 6 to 8.
This advertisement is only for 1 to 5 or 6 to 8 also?
Both, my lord. Primary and upper primary, both.
So you are only concerned with primary.
Both, my lord. Both.
Primary and upper primary. So your petition is of primary.
Both are not mixed, in fact.
Correct. You are also
Because
Both have both.
we have to see both.
it's elementary education which has defined as class 1 to class 8. So it's split into 1 to 5 and 6 to 8 for the purpose of the qualification. But otherwise it's both. It's all of it.
Now, what is next?
Stress by some pointing out some judgments about how it is relevant and important. Why states have the power to fix their own jtet, why they are conducting it themselves. In fact, the recent one was Devesh Sharma judgment, Lord, in which they consider the importance of the elementary education and the primary education. How the teachers, in fact, Lord, the court said B.Ed also is not relevant today. It's only TET. Diploma and DLED is relevant.
Letter tomorrow
Very well.
and take this.
Give you the dates also. Sorry about that.
Correct. You revise it and give it revised.
Just not.
And give the compilation of the judgments also.
Very well.
Tomorrow. Give them. Return it back. Okay. So, batch of returned. How many cases are listed today?
Not only three.
Six.
Okay.
Batch of.
2 of Jharkhand.
Here you tomorrow.
Slightly different. I mean, detag. Bihar's case may be detagged. Slightly different.
Both are brother, sister.
They have challenged our rule. They have challenged the rule, man.
Consider that. Why we should
No, well, it's different. Anyway, not specifically.
consider
Yes,
we have
they
not
have
heard.
allowed Jharkhand.
But we have not had it, yes, man. We are not having it.
Look away. We Learned counsel for the petitioners are heard. For further arguments, this tomorrow. Registry is requested. List this case tomorrow, if necessary. Kindly obtain order from Honorable the Chief Justice.
You have been granted permission?
Lordship's permission, my lord. Item 35, my lord. I'm sorry, not present when it was called, my lord.
Today now it cannot be possible.
No, I understand, my lord. Would it be convenient to have it on a Monday, Friday, my lord, or on Wednesday?
It will take time, Mr. Mehta. I've seen that case also.
I see.
I've seen that matter also.
Very well.
All right, there are so many documents filed by the respondents. They say this is a bundle of the documents filed, like this. So we have to look into. And it's a case.
Or Wednesday or Thursday, any Wednesday, Thursday, my lord.
We will take it in the next Tuesday, what we can do.
No, it is a miscellaneous
A miscellaneous day, my lord. Monday is a holiday.
14.
Oh,
we will,
That
we will take then 24.
I was only requesting
24 we will take on 24.
24th. I have difficulty, my lord.
Then we take on first.
Wednesday is not possible, my lord. Any Wednesday.
Wednesday not. Wednesday will not be listed. We know. Therefore, this case, because we have heard for a long time, so we requested to take order from Honorable the Chief Justice.
I see. I see. All right, my lord.
Yes.
Very well.
First October. All right, 1st October.
First up.
Very good.
Item number 26, notes landed position.
So what is the urgency in that?
We are not available for anything now.
Not getting who is for the other side?
That is the
Who is for the other side?
Mr. Nanda.
Huh?
Mr. Nanda, please get it located.
So we take now this matter, then in October, we give a fixed date. We'll give you a fixed date on that.
Lordship, may I mention item number 16?
Item number
16, Lordship.
26 को कोई डेट दे दीजिए अक्टूबर में 22nd of October.
Lordships,
Take in November better. 12 November. 12 November.
Lord,
12.
Lordships, Lord, may I mention, Lordships, Siddharth Luther, that back wages matter. My learned friend is here, which your Lordship
Yes, please. What happened in that?
Had a discussion. The figures are slightly distant, but we will try.
Lordships, may I have it on? They are also here.
I'm also trying to persuade my client
You have to mention.
to come to a settlement.
Madam, we have seen that completely, that case we have seen. You have to decide the back pages. How much you are asking?
Lord, our figure is around 1 crore. They have come to 62 lakhs. Now, the point is this, Lord, we said if you are giving us 1 CR as per our wish, we can do a golden handshake, the person can leave the institution. If they are willing to pay 62 lakhs, then he has got 16 years service left, let him continue in service. So yesterday, my lord, the gentleman who joined from their side said that he's an excellent teacher. The students are very happy. So we want continuity in service. Now that 62 lakhs, they want to make some deductions. So my lord, if it's reasonable, perhaps my lord, we'll agree 60, 59, 58, whatever. But my lord, otherwise, if they want to give a golden handshake in 58 lakhs or 55 lakhs, that becomes difficult, my lord.
Another thing is
And it's without interest, without the promotional benefits. Yes, my lord.
Difficult, not difficult. It's our choice.
Yes, my lord,
So
certainly.
if you feel it is a difficult, it would be difficult for 5 lakhs, 10 lakhs.
No, my lord, for 5 lakhs, 10 lakhs, I'm not saying that. I'm only saying, my lord, if they're paying us 50 lakhs and getting a golden handshake that leave the institution, that becomes slightly difficult.
Certainly,
Some figure in between 62 lakhs and 90, I told my learned friend, I can get him to agree for a golden handshake. Otherwise, let him continue in service, my lords, with 60 odd lakhs. So, I think just 1 second, please.
taking other similarly days.
So now that is not.
If it is the 62, then you have to aggregate all days like him.
Now, my lord, how can,
madam, you find out a way we have already said to you.
my lord, next week,
पे भी date लगाते हैं.
very well.
Lordship, may I mention item 30?
Deeply obliged.
Lordship,
May I mention item number 16?
Yes.
16. It was listed today, but it has not reached.
Lordship,
Lordship, 4 weeks time may be granted.
For inability.
Your Lordship, may I mention item 30, Your Lordship? Lordship, yesterday I filed the... Lordship, it was an item for suit for specific performance which has been stayed. All the lower courts were in our favor, Your Lordship. We have filed the counter affidavit.
16 counter affidavit.
Yes, no, sir. Item number 30, Your Lordship. 4 weeks time may be granted.
You are asking for 16 now?
No, yes, Lordship.
16, I'm
Counter affidavit not filed.
16, I am here for state, my lord.
4 weeks time may be granted to file the counter